So good morning. I am delighted today to introduce you to Professor Francesco Biagi from the University of Bologna and the Johns Hopkins University. Francesco is a scholar that has a young scholar that has already a rather impressive record. He spent a couple of years at the Max Planck Foundation of International Peace in Heidelberg, where he worked in the field of constitution making, and he still advises judges, courts in developing countries. So he's part of training programs for judges operating in those contexts. He's also a permanent visiting fellow at the College of Illinois, where he teaches comparative constitutional law, and for our purposes is mainly the author of this important book. The book is in Italian, but I've been told yesterday there is an ongoing translation in English. So in few months we'll have the English version available. The title of the book is Corti Costituzionali e Transizioni Democratiche, Tre Generazioni a Confronto. So Constitutional Courts and Democratic Transitions, 3 Generations Compared. It is an important book because it tries to identify the role played by constitutional courts in constitutional transitions by focusing on 3 distinct experiences: the experience of the Italian Constitutional Court, the experience of the Spanish Constitutional Court, and the experience of the Czech Constitutional Court. And this is mainly the topic he will deal with in his lecture today. Just to sum up a few things we should know, we touched upon constitutional transitions in Unit 3 when we talked about constitution making. And we said at that point that constitutional transitions are a peculiar form of constitution making, implying a change from mainly an authoritarian regime to a democratic regime. This change takes place gradually. It is not a sudden change, and this gradual nature of the change is mostly the result of the fact that there are rising political forces, but are not as powerful as to overturn completely previous incumbent political parties. As a consequence of this, in the impossibility of starting a revolutionary-based process of constitution making, in constitutional transition we find the negotiation between declining powers and rising powers. And this negotiation produces a sequence of constitution acts that hopefully result in a new democratic constitution. And this is something we mentioned: the experience of Spain, the experience of Hungary and Poland, the experience of South Africa. Only in this regard we noticed that constitutional courts may play a role. If you remember, in the experience of South Africa, the Constitutional Court was expected and did review the constitution in the light of the interim constitution. The constitution was certified, and the Constitutional Court also found that in a number of aspects the new constitution was not complying with the interim constitution. But apart from this aspect, constitutional courts were not within the radar in the discussion of constitutional transition. So today we have the opportunity to identify this aspect that remained marginal in my discussion, but the contribution of constitutional courts in the process of transitioning between an authoritarian regime and a democratic regime, as we are going to see, is critical, is extremely important. So without further ado, I leave the floor to Francesco, and I will check now what's going on with the slides. Francesco,
First of all, okay, excellent. I would like to thank Marco Dani for inviting me. It's really a pleasure and an honor to be here at the Faculty of Law of University of Trento. So as Professor Dani said, in my presentation I will talk about the role of European constitutional courts in constitutional transitions, and my presentation will be divided into 5 main parts. In the first part, guys, I will stress the fact that the establishment of constitutional courts in Europe was strictly linked to the processes of democratization. Then I will, in the second part, analyze some of the major challenges that European constitutional courts had to face during the first years of their activity. Then in the third section I will examine some of the most relevant factors that have affected the action of constitutional courts. Then in the fourth part I will talk briefly about the issue of legitimacy of constitutional courts, legitimacy of constitutional courts within the context of a process of transition. And then I will draw some concluding remarks. So, and this is something that Professor Dani has already mentioned. In this presentation, which is based on my book, I will talk about 3 generations of European constitutional courts that were all established after the collapse of an authoritarian regime. So we have the first generation with the constitutional courts of Germany and Italy that were established after World War II, after the collapse of the Nazi regime in Germany and the fascist regime in Italy. I will also look at the second generation, so constitutional courts of Spain and Portugal, established at the beginning of the 80s, following the collapse of the regime of Salazar in Portugal and after the death of Francisco Franco in Spain. And then we have the third generation with the post-Soviet constitutional courts, so the constitutional review bodies that were set up after the collapse of the Soviet Union, after the fall of the Berlin Wall in 1989. So 3 generations. By the way, don't worry because I will give you all the slides. So this is something that you will be able to rely on. The first aspect that I would like to stress is the fact that there is a very strict relationship between the setting up of constitutional courts and the processes of transition to democracy. In general terms, guys, what we can say is that constitutional courts represented a sort of reaction to the previous autocratic regimes. So these bodies, guys, were considered a sort of symbol of the new democratic system. But they also represented a sign of distrust towards against the legislative branch. The legislative branch had committed a series of abuses under the previous authoritarian regimes, and courts were considered a kind of protection against possible arbitrary legislative power. What is even more interesting, in my opinion, is that constitutional courts were also considered a sign of, were established because of there was an evident distrust towards ordinary judges. But guys, not ordinary judges as such, but ordinary judges that had been selected and had been trained under the previous non-democratic regime. So the fear of a lot of constitution makers was that these judges were not going to be particularly sensitive to the principles and values contained in the new constitutions, in the new democratic constitutions. And as we'll see, guys, this risk, this fear was well-founded. And then there is also another element that we have to take into account that, which is not often stressed enough by the literature, the influence of supranational organizations. And now I'm referring in particular to the courts of third generation, post-Soviet constitutional courts. Certain supranational organizations, and here I'm referring in particular to the Council of Europe, but also to the Venice Commission, you know, the constitutional, an advisory body of the Council of Europe on constitutional matters, strongly recommended the establishment of a strong system of constitutional adjudication, and strongly recommended in particular the establishment of constitutional courts. They said they worked pretty well in Germany, in Italy, in Spain, in Portugal. You should also establish this constitutional review body that will facilitate the process of transition to democracy. So these are some of the most important reasons that explain the birth of these bodies. But guys, and this is a very important point, despite the fact that in the vast majority of European countries we have constitutional courts, the setting up of these bodies was not taken for granted during the constitution-making process. It was really a troubled birth. The first problem, guys, that it was necessary to overcome what I say the dogma of the parliamentary supremacy, of parliamentary sovereignty, that came, you know, from the Jacobin ideals of the law as the expression of the general will, la loi expression de la volonté générale, more in general the myth of the representative assembly, you know, the idea according to which parliament can do and undo whatever it wants. So establishing a body in charge of striking down laws adopted by parliament, so by the majority of the representative of the people, was problematic for some constitution makers. And then there is also another important reason. There was the fear that the constitutional courts would have played a conservative role rather than supporting reforming policies. Especially, you know, after World War II, so during the 50s, the 60s, but even before, the law, guys, was considered an instrument of conservation more than an instrument of transformation. In Central and Eastern Europe, the situation was a bit different, in the sense that during the constitution-making process, the setting up of a constitutional court was never seriously debated, but as soon as the constitutional courts were set up, parliaments immediately started to question the legitimacy of these bodies. So either during the constitution-making process or immediately after, you know, the establishment of these constitutional review bodies was, in a way or another, questioned. Here you have on your left Palmiro Togliatti, the leader of the Communist Party, of the Italian Communist Party. During the debates within the Constituent Assembly, the 11th of March 1947, he said, the Constitutional Court is a bizarre idea. The Communist Party and more in general left-wing parties were not favorable to the setting up of a Constitutional Court. On your right, you have Jordi Soletura, a member of a left-wing Spanish political party. He said, the Constitutional Court will be difficult to keep in check. I'm quoting. The risk is that it will become a kind of third chamber that will end up imposing its will on Congress and the Senate, thus putting a brake on their actions. In general, guys, members of left-wing parties, socialist parties, but in particular communist parties, were against the setting up of a constitutional court. In Italy, it was very evident. The Christian Democrats were in favor of the establishment of a court. The communists were against. Then immediately after the elections in 1948, the situation changed radically. the Christian Democrats won the elections, so they had the majority, so they tried to postpone the establishment of a constitutional court because it was a counter-majoritarian body, whereas the left-wing parties, started to push for the introduction of this body, of the constitutional court. So what are the challenges, guys, that these courts have to face? And this is going to be one of the cores of my presentation. I think that we can divide the challenges into two parts. First of all, we have the common challenges. So challenges that almost all European constitutional courts had to face. And as you will see, and now I'm going to discuss them in detail, the first challenge regarded the upholding of the normative value of the Constitution. And the second main challenge regarded the protection of fundamental rights. But then, guys, we also have to consider certain specific issues that arose from the individual processes of democratization. So there were common challenges, but also challenges that regarded each individual country. I will give you some examples concerning Italy, Spain, Central and Eastern Europe, and also Germany. But let's start with the common challenges. The first challenge, guys, as I said, was to uphold the normative value of the Constitution. But in order to understand this problem, guys, it is important to take a step back. Maybe you already know that, but for a long time, the notion of the Constitution in the United States was very different with respect to the notion of the Constitution in Europe. For the following reason. In the United States, guys, the Constitution has been considered from the outset, since the very beginning, a legally binding text. And in particular, it was considered the highest law of the country. And this was made clear in one of the most important judgments of all times. I'm sure you are already familiar with it. The case is Marbury versus Madison, 1803. Do you remember what this case is about and why this case is so important? What is the core principle expressed by the U.S. Supreme Court in this case? Yes?
Any law requirement of the Constitution is void.
Excellent, perfect. An act of the Congress, which is in contrast with the Constitution, is null and void. And the reason is that the Constitution is not just an ordinary law, and this is what Chief John Marshall said, but the Constitution is the superior, the paramount law of the country. In Europe, guys, the situation for a long time, the notion, of the Constitution for a long time was very different. The Constitution was not considered a legally binding text. It was considered more either as just a symbolic document or, in the majority of the cases, a political document. But as I said, without any legal value. This is evident if you look at the French revolutionary constitutions, 71, 1793, 1795, but also if you look at all the constitutions adopted in Spain during the 19th century, and there are many other examples. Again, the reason has to do with the particularly strong influence of the Jacobin ideals of the supremacy of parliamentary supremacy, of the supremacy of statute law. So now I'm oversimplifying, but just for you to get the idea, in Europe for a long time the ordinary statute law was the supreme law of the land, not the Constitution. In this picture, guys, you have Eduardo García de Enterría, who is one of the most prominent Spanish constitutional scholars. He wrote a seminal book called La Constitución como norma jurídica y el Tribunal Constitucional. The Constitution as a legal norm, as a juridical norm, and the Constitutional Tribunal, the Constitutional Court. Eduardo García de Enterría, who in this book was arguing in favor of a a normative conception of the Constitution, and we'll see in a second why this was so important, said before the last World War, so before the Second World War, the Constitution was not anywhere in Europe a norm that was actionable before the courts. But I think that is also emblematic what Hans Kelsen said so the inventor of the Constitution in 1929, in this seminal article published in the Revue des droits publics et de la science politique en France et à l'étranger, he said, as long as a constitution lacks the guarantee of the annullability of unconstitutional acts, it also lacks the character of full legal bindingness in the technical sense. A constitution according to which unconstitutional acts, and in particular unconstitutional statutes, must remain valid because they cannot be annulled on the ground of their unconstitutionality, amounts to little more from a technical point of view than a non-binding wish. So if you cannot annul laws which are in contrast with the Constitution is a little more than a non-binding wish. This is what Kelsen said in 1929. Things changed, guys, in particular thanks to the establishment of constitutional courts following World War II, because the European constitutional courts, guys, basically started to do what the US Supreme Court had done since the beginning of the 19th century, since Marbury versus Madison. So they started to declare the legally binding value of the Constitution. They started to look at the Constitution not just as political documents, but as normative, legally binding texts. There are hundreds of examples. I've only picked the case of Spain just to show you that in Europe, at the end of the 80s, we were still debating about this idea of whether the Constitution was a political document or a legally binding text. You know, the Spanish Constitutional Court was established in 1980. The Constitution is of 1978. The court starts to operate in 1980, and in one of the first judgments delivered by the court, number 16 of 1982, the court says the Constitution is a law, the supreme law of our legal system, and the citizens and the public institutions are subject to it. By the way, the words used by the Spanish court are not too different from the words used by the US Supreme Court in Madison, in Marbury versus Madison. In Marbury, the Supreme Court says the Constitution is the superior, the paramount law of the land. Here the court says, the Spanish court says the Constitution is the supreme law of our legal system. But even more interesting is the second judgment, number 80 of 1982. Here, guys, the Constitutional Court was forced to declare the legally binding value of Article 14 of the Spanish Constitution, which proclaims the principle of equality. Guys, the principle of equality is one of the pillars of constitutionalism in all democracies all over the world, right? We all agree on that. Just a few months before, the Supreme Court of Spain, not the Constitutional Court, the Supreme Court, so the court which is placed at the apex of the pyramid of the ordinary judiciary, said that Article 14 was only a declaration of principle which lacked any legal value. So the Supreme Court in this judgment said that you cannot immediately enforce Article 14. It was not immediately enforceable. The Constitutional Court, a few months later, in this judgment, 1982, said we have to consider all the provisions of the Spanish Constitution as legally binding, including Article 14. They can all be immediately enforced. Okay? So a radical change. This took place in Spain, this took place in Italy, in Germany, and guys, although to a lesser extent, but this was also the case in many Central and Eastern European countries. So the first challenge, the first issue that constitutional courts had to face was to guarantee the normativity of the Constitution. The second challenge regarded the protection of fundamental rights. it goes without saying that it was particularly important because during the previous authoritarian regimes, fundamental rights were the object of a systematic violation. So the courts played a very important role in marking a discontinuity with the past, also from this point of view. You know, from a situation of a systematic violation to a situation in which rights and freedoms were much more guaranteed. Here it is interesting to, in my opinion, to try to identify the most important factors, variables that favored the protection of fundamental rights. There are a lot. I only picked in this presentation 2. The first one, guys, is given by the diversified procedural gateways to the Constitutional Court. So the fact that a lot of different actors could appeal to the Constitutional Court, the fact that there were different procedural pathways to have access to the Constitutional Court. And I will come back to this in a few minutes. You know, the possibility in some countries, for example, for the citizens to directly lodge claims before the court, Verfassung Beschwerde, Recurso de Amparo, and so on. You know, also political authorities could refer cases, orderly judges, and so on and so forth. Second element, guys, and this is particularly important, in my opinion, this is one of the factors that really made the difference, which is given by the growing internationalization of constitutional law, and in particular, in increasing attention to human rights in the period after World War II. The so-called human rights discourse became, in Europe and in the world, more and more prominent, more and more important. And it's not a coincidence that it is in this period that we have really a proliferation of international human rights treaties and conventions. These are documents that probably you are already familiar with. 1948, the Universal Declaration of Human Rights. This is probably the beginning of everything. And then we have the International Covenant on Civil and Political Rights, and the Covenant of Economic, Social, and Cultural Rights, 1966. And then, you know, another international convention that probably you're already familiar with, which is the European Convention on Human Rights. Again, these documents represented in some ways a reaction to the atrocities committed, you know, during the previous authoritarian regimes. This is evident, for example, if you read the constituent debates concerning the adoption of the European Convention of Human Rights. But what is, I think, particularly interesting is also that in the first years of their activity, guys, constitutional courts started to lay the foundations of the core principles of their jurisprudence in the field of protection of fundamental rights. And I will give you some examples. It is in the very first judgments of European courts that we have, for example, the references to the principle of the limits to rights. Rights, freedoms, you know, have certain limitations. In the very first judgment delivered by the Italian Constitutional Court, number 1 of 1956, the court says the concept of limit is implicit in the concept of law, and within the legal order, the various juridical spheres must mutually limit each other in order for them to exist alongside each other in an orderly civil coexistence. Another example, the identification of the essential content of fundamental rights, the identification of the core, the essence of fundamental rights and freedoms. This is an issue that, guys, constitutional courts are still debating. You know, in all the judgments that they deliver, very often they have to identify this core content. The Spanish Constitutional Court, in one of its first judgments, number 11 of 1981, precisely addressed this question, this issue. We'll read only the second part of this excerpt. It says that the essential content of the right is disregarded when the right is subject to limitations rendering the exercise of the right impracticable or difficult to an unreasonable extent or devoid of the necessary protection. Guys, this is still considered, after 30 years, the cornerstone of the jurisprudence of the Spanish Constitutional Court when it comes to the identification of the content of the essential content of fundamental rights. Two more examples. The principle of reasonableness. Another fundamental principle used by constitutional courts when they, especially in the field of protection of fundamental rights. Here I picked a judgment delivered by the Italian Constitutional Court, number 15 of 1960. The principle of, was talking about the principle of equality. The principle of equality is violated also when the law, without a reasonable motive, provides for different treatment of citizens who find themselves in equal situations. And then the last example, the issue of proportionality. Again, this is one of the most important principles used by constitutional courts and also by Supreme Courts when they have to protect fundamental rights, when they have to balance, rights. And if there is in Europe a constitutional court that can be considered the champion in the use of proportionality, in the proportionality test, this is the German Bundesverfassungsgericht. Here you have a reference to a very famous case, the Luthor Case of 1958. The court says the right to express an opinion must yield if it exercise infringes interests of another which have a superior claim to protection. Whether such an interest exists depends on all the circumstances of the specific case. So what I'm saying, to sum up, is that in these first judgments, guys, at the very beginning of their activity, the constitutional courts lay the foundation of the core principles of their jurisprudence in the field of protection of fundamental rights, regarding the notion of limits to rights, regarding the identification of the core content of fundamental rights, regarding the principle of reasonableness, regarding the principle of proportionality. Moving on to to certain specific issues that courts in Europe had to face. I would like to start with the case of Italy. In Italy, guys, the main problem, the main issue that the court had to face regarded the the elimination of the authoritarian legislation, of the previous fascist legislation. Why? In Italy, guys, what happened was that the vast majority of fascist legislation was transferred en bloc to the new democratic system. I'll give you some examples. The criminal code, Codice Rocco, the Code of Criminal Procedure, the Unified Text on Public Security, Testo Unico di Pubblica Sicurezza, all codes, laws adopted under the previous authoritarian regime, clearly in contrast in a lot of cases with the new constitution, with the new democratic constitution, simply transferred en bloc to the new republican and democratic system. So basically, guys, you had a new brand democratic constitution squeezed into a context that was in part still authoritarian, because these laws, were still in force. And the problem was even more serious because the Constitutional Court of Italy was set up only in 1956, 8 years after the adoption of the Constitution. What happens between 1948 and 1956? Italy was characterized by a decentralized system of constitutional adjudication. Do you know, guys, what's the difference between a centralized and a decentralized system of constitutional adjudication? What's the difference, guys?
Decentralized, like the USA, in which there is not a central court.
The decentralized.
Decentralized.
Yes?
In which there is not a central court, central constitutional court. While in the centralized one,
And in the US, who is responsible for checking the constitutionality of all courts? Very good. All courts of all types and all levels, whereas in a centralized constitutional system of constitutional adjudication, only the constitutional court. Very well. So in Italy, between 1948 and 1956, we had this decentralized system, which did not work very well. In my opinion, it was let's say that it did not work particularly well. The problem was that only very few laws were considered in contrast with the Constitution. And there is a reason for that. There are many reasons, one which is more important than the others. This reason has to do with the fact that the Italian Court of Cassation delivered an important judgment just 1 month after the adoption of the Constitution, the 7th of February 1948. A judgment in which it drew a distinction between the programmatic constitutional provisions, norme programmatiche, on the one end, and the preceptive constitutional provisions on the other end, norme precettive. And according to the Court of Cassation, only the preceptive constitutional provisions, norme precettive, could repeal pre-constitutional laws in contrast with the Constitution, could repeal the fascist legislation in contrast with the Constitution. Programmatic provisions could not do that, only the preceptive ones. This distinction was followed to a large extent by ordinary courts, and in particular by the apex courts, such as the Court of Cassation and the Council of State. But guys, the main problem was that, especially the apex courts, considered as programmatic provisions a lot of provisions dealing with fundamental rights. For example, Article 21, freedom of expression, the one of the cornerstones of every liberal democratic system, was considered only a programmatic provision, and therefore it was not entitled to repeal the pre-constitutional laws in contrast with the Constitution. Is this concept clear, guys? Yes, please. Sure, yeah, good question. So basically the Court of Cassation said that programmatic constitutional provisions were only programs for the legislator, but these were provisions that could not be immediately enforced. On the contrary, the preceptive constitutional provisions were not simply programs, were not simply indications for the legislator, but they were norms that could be immediately enforced and put into practice, that were immediately actionable before the courts. Okay? This is Piero Calamandrei. Do you know, guys, who Piero Calamandrei is? Piero Calamandrei is one of the founding fathers of the Italian Constitution, one of the most important, most prominent constitutional law scholars. He was very critical about the situation in Italy in those years, between 1948 and 1956. And in a very important article written in 1955, he said the Constitution has never actually been implemented in the way it is written. Rather, in recent years, what has slowly taken place is a steady restoration of the old order, so of the fascist order, a regime that is completely different from the one specified in the Constitution, from which the government has actually moved further away day after day. As I told you, we had a new constitution, democratic constitution, squeezed into a context that was in part still authoritarian, because instead of applying the provisions of the Constitution of fundamental rights and freedoms, very often courts continue to apply the old authoritarian legislation, continue to apply the provisions of the criminal code, of the Code of Criminal Procedure and of the Testo Unico di Legge di Pubblica Sicurezza. With Judgment 1 of 1956, first judgment delivered by the Italian court, Constitutional Court, right? This was represented a real watershed in my opinion, also in the history of the Italian transition to democracy. This judgment said two fundamental things. First, that the Constitutional Court itself was entitled to check the legitimacy, the constitutional legitimacy of pre-constitutional legislation. This was something that could not be taken for granted, especially because the government, that at the time was quite conservative, had stated that the Constitutional Court was not entitled to check the constitutionality of pre-constitutional legislation. The government said the Constitutional Court can only check the constitutionality of laws adopted after the promulgation of the Constitution. The Constitutional Court said, no, it's my duty it's my task to check all kinds of laws, irrespective of whether they were adopted before or after the Constitution. So I can check also the constitutionality of fascist laws. And second fundamental principle proclaimed in this judgment is that even the programmatic constitutional provisions could repeal the pre-constitutional statutes in contrast with the Constitution. So if there was a contrast between a fascist law and a programmatic constitutional provision, the fascist law had to be considered in contrast with the Constitution. And this is precisely what happened in this judgment. There was an article of the Testo Unico di Pubblica Sicurezza, Unified Text of Public Security, Article 113, that stated that distributing posters and newspapers could only take place with the prior authorization of the police. The court said this is in contrast with Article 21, free speech. If you have to ask for the prior authorization to the police to exercise your right to express your opinion, to distribute posters, newspapers, and so on and so forth, you have a violation of the principle of free speech. So guys, from this judgment until the end of the 60s, beginning of the 70s, the first season, the first phase of the Constitutional Court, the Italian Constitutional Court, little by little, declared a lot of, probably the majority of the laws, of the fascist laws that were in contrast with the Constitution. In Italian we use the expression bonifica della legislazione fascista, elimination of the fascist legislation. He did quite a good job, that's true, but we also have to say that in certain fields, for example in the field of public order, probably the Constitutional Court was excessively cautious and decided, for example, not to declare laws that were probably in contrast with the Constitution. So in certain fields, probably it lacked a bit of courage. But as we'll see, there are explanations for this. What really counts, however, is that at the end of the day, after these 15 years, most of the previous authoritarian legislation had been declared unconstitutional. Guys, this was particularly important in my opinion because in 1956, this is my personal opinion, Italy could not be considered a fully democratic state, a fully democratic country. There were still a lot of elements that show the fact that the country was probably a sort of an hybrid regime with a new democratic constitution, but with elements that were still closely related to the previous authoritarian regime. Thanks to the activity, thanks to this action of the Constitutional Court, the Italian Constitutional Court experienced a transition from a hybrid regime, as it was in 1956, to a fully democratic system. Okay. Okay, guys. Now I would like to give you another example of one of the challenges that European Constitutional Courts had to face, and I'm referring in particular to the case of Spain. In Spain, one of the most serious, one of the most problematic issues that the Spanish Constitutional Court had to address regarded the territorial organization of the state, which was crucial for a successful transition to democracy. And obviously the main reference is to the Catalan issue and to the Basque issue that especially at the time was probably even more problematic. In Spain, guys, the creation of the comunidades autónomas, of the autonomous communities, so the regions that composed the state, their creation represented in a way the reaction to the absolute centralism of the regime of Francisco Franco. You know that Franco, when at the end of the 30s in 1939 got the power, he immediately eliminated the two autonomous regimes that existed at the time, the Catalan form of autonomy and the Basque autonomy. So what the framers did after the death of Franco was to try to meet, as much as possible, within certain limits, the aspirations, the claims of the nationalists, obviously in particular of the Basque and the Catalan nationalists. And then there is also another issue that we have to consider, the issue of Basque terrorism, which should not be underestimated. You know the terrorist organization called ETA? Well, ETA reached the top, the peak of its strength precisely during the years of the transition to democracy. Between the end of the 70s, beginning of the 80s, ETA committed hundreds and hundreds of terrorist attacks, of murders every year. So the situation was really particularly problematic. Here you have a picture, guys, that was taken just in the first few months after the death of Francisco Franco. It is a picture taken in Barcelona. It says Libertad, Amnistía y Estatuto de Autonomía, freedom, amnesty, and statute of autonomy. This shows the fact that territorial autonomy for the Catalans, but also for the Basques, was one of the major requests that the protesters, made, after the death of Francisco Franco. It was, as I said, a conditio sine qua non for a successful transition to democracy. It was crucial, essential for a transition from the previous Francoist regime to a new democratic form of government. But there was a problem. The new Spanish Constitution of 1978, Title 8, regulates the territorial organization of the state. It provides for, the Spanish say, Estado de las Autonomías, a state of autonomies, a sort of regional state, in certain ways similar to the, to the territorial organization that can be found in Italy. There are also many differences, but in a way it is similar. However, this part of the Constitution, guys, was particularly problematic. The drafting was quite poor, according to a lot of scholars. Here there is a quotation from Luis López Guerra, a Spanish scholar. He said that this part of the Constitution was an absurd and contradictory construction. He even said it was a chaos without hope. So the Constitutional Court of Spain found itself in a quite problematic situation. So, and the crucial task, the crucial role that it played was to guarantee a rational functioning of the autonomous state in three main ways. First of all, it specified, it clarified the meaning of a series of constitutional provisions that were quite vague, that were not particularly clear regarding, the territorial organization of the state. It also filled the gaps of the Constitution. And third, it resolved the conflicts between the central government and the regions and the autonomous communities, and also between autonomous communities. And in particular, this resolution of territorial disputes was of the utmost importance, in my opinion, and according to many other scholars, because it guaranteed a peaceful resolution of these political disputes. Without the possibility to lodge claims before the Constitutional Court, it is probable that these political disputes would have worsened, would have deteriorated. I'm not saying, guys, and this is something that I want to clarify, I'm not saying that the Constitutional Court resolved the political tensions that existed in Spain. And we have a clear demonstration of the fact that these tensions concerning the territorial organization of the state are still existent. The case of Catalonia is evident. But at least in the light of this very confusing constitutional framework, the Constitutional Court guaranteed quite a rational functioning of the state, especially for the first 10-15 years, until the 1995 and maybe even a bit later. And the role played by the court was so important that Spanish scholars used the expression construcción jurisprudencial del Estado de las Autonomías, jurisprudential construction of the state of autonomies, in order to stress the fact that the state of autonomies was built also thanks to the judgments delivered by courts, and in particular thanks to the judgments delivered by the Constitutional Court, when it clarified the meaning of the constitutional provisions, when it filled the gaps of the Constitution, and when it decides on the disputes between Madrid and Catalonia, between Madrid and the Basque Country, and so on and so forth. And then the last example that I'd like to give you regarding the challenges arising in individual countries refers to Central and Eastern Europe. Here, guys, the major challenge regarded the so-called transitional justice. Here you have a definition taken from Rudi Teitel, who is one of the greatest experts, probably the main expert on transitional justice, in an article published in the Harvard Human Rights Journal in 2003. Teitel says, transitional justice refers to the conception of justice associated with periods of political change characterized by legal responses to confront the wrongdoings of repressive predecessor regimes. To put it in more simple words, and this is what the experts on transitional justice say, the aim of transitional justice is to deal with the past, is to deal with the previous authoritarian illiberal regimes. You can deal with the past, guys, in a number of different ways. And communist countries adopted certain legal measures in order to do so. For example, they adopted laws on the restitution of property. Why? Because during the communist regime, the regime had confiscated in a lot of cases, the property. So the issue was how and to what extent could property be returned to the original owners. And that's why these laws were adopted. Another example, the laws on the reopening of the statute of limitations. These laws, guys, excluded from the statute of limitations those people who had been acquitted for political reasons that were incompatible with the democratic society. So again, the problem was how these laws, to what extent, these laws could reopen the statute of limitations, especially because...
Can you define statute of limitations? Because
Sure.
This is something we haven't talked about.
Sure. The issue, guys, is that there is a general rule in criminal law which is given by the ban on retroactive criminal legislation. So if you commit a crime and after a certain period of time this crime cannot be prosecuted any longer. Okay, this is the statute of limitations. So the idea of after the illiberal regime to reopen the statute of limitations was considered a ban, was considered a sort of violation, according to some scholars, on this ban on retroactive criminal legislation. Is it clear? And then the third example, which I'm going to focus on, refers to the lustration laws. Have you ever heard about this expression? I know that some of you come from Eastern Europe, so maybe you have already heard about, no. Okay, lustration laws, guys, are laws which are aimed at preventing the members of the communist regime or people who are in a way or another interested in returning to this previous regime from holding important posts within the state apparatus, within the state administration. So, for example, if you were a member of the Communist Party, you were prevented from holding an important post at the university, in a state-owned enterprise, at the government, in parliament, and so on and so forth. These kind of provisions, guys, were incredibly problematic. And the question that I would like to ask you is, why do you think that, also from a legal standpoint, adopting these kind of laws is problematic? And this explains also the fact that constitutional courts adopted different positions, different approaches with respect to these laws. Some constitutional courts said that these laws were in line with the Constitution, for example, the Czech Constitutional Court. Other courts, the majority, said that they were in contrast with the Constitution. Why do you think that these laws are problematic? Yes, please. Perfect. Perfect. Principle of equality, or also principle of, strictly related to the principle of equality, non-discrimination, for example. And then there is also another problem. It's also problematic from the viewpoint of the right to? Not really. There is another problem that constitutional courts have underlined, the right to work. I mean, you decide to prevent certain categories of people from working in certain fields. And this is something that constitutional courts stressed. I just want to give you very briefly an idea of the type of arguments that constitutional courts use to justify their reason, why they decided to uphold or to strike down these laws. In the Czech Republic, the Constitutional Court said, as I said, that these laws were in line with the Constitution. The court said we have to uphold these laws because they are necessary to protect the democratic system. It's very clear. This is a quotation from Judgment number 9 of 2001. The lustration laws still pursue a legitimate aim, which is the active protection of a democratic state from the dangers which could be brought to it by insufficiently loyal and little trustworthy public services. In 2001, guys, so almost 10, 11, 12 years after the end of the transition of the revolution, of the Velvet Revolution, the court is saying that it is still important to adopt these laws to protect the democratic system of the country. And here, guys, what is interesting that there is a clear reference to the idea of a democracy capable of defending itself. This is an expression which can be often found in the case law of the European Court of Human Rights. So a democracy which actively act in order to defend itself from the dangers, coming from outside and from its side. And in fact, in this decision of the Czech Constitutional Court, there are a number of references to the judgments delivered by the European Court of Human Rights on this idea, a democracy capable of defending itself, which is in part similar to the idea of a militant democracy. I don't know whether you talked about that, but I will come back to this idea of the militant democracy in a second. And then the Czech court also talks about the idea of a material conception of a state based on the rule of law. It says, if we look at the two regimes, the communist regime, the democratic regime, they are based on completely different values, completely different principles. And the court says the concept of rule of law mainly refers to respect for those norms which are not incompatible with the principle of human society. The reasoning, for example, of the Hungarian Constitutional Court, that on the contrary, declared the unconstitutionality of these laws, was diametrically opposed, completely different. First of all, because the court says the transition is over. This judgment is from 1994, so a few years after the end of the transition, the court says that the transition is over. It is an historical fact. We are not any longer in a process of transition to democracy. So the instruments, the tools that we have to use in order to check whether these laws are in contrast or not with the Constitution are the same tools, the same values that, must be used in a normal, in an established democracy. In a normal democratic society, guys, according to the Hungarian Constitutional Court, you cannot prevent people, even if they were members of the communist regime, from holding important posts in the state administration. And as I said, the reason was that this was in contrast with the principle of equality, non-discrimination, and some courts also made reference to the violation of the right to work. Okay, so very different conceptions, very different approaches. Just a very quick reference to Germany, because the German Bundesverfassungsgericht dealt with a number of issues during the transition process. Here I just wanted to tell you very briefly that one of the issues that the court had to deal with concerned the power of the court to verify whether political parties respected or not the principles of the Constitution. You know that there is a provision of the German Basic Law that says that the court has the power to declare the unconstitutionality of parties that by reason of their aims or the behavior of their adherents seek to undermine or abolish the free democratic basic order in order to endanger the existence of the Federal Republic of Germany. That's why Germany is included among those countries that are defined by scholars as militant democracies. This is the expression that was used for the first time by Karl Lovenstein in an important article. Used the expression militant democracy, and now scholars very often refer to it. The court declared the unconstitutionality of a political party in two cases in all its history. In 1952, the Socialist Right Party, so a neo-Nazi party, was considered not in line with the principles of a democratic state. And then in 1956, when the court dissolved the Communist Party. For the purposes of this class, guys, what I would like to stress is that the fact that we were in Germany at that time in a context of a transition process, the fact that Germany at the time was not an established democracy, was still a fragile democracy, in my opinion, strongly influenced the decision of the Constitutional Court. It's not a coincidence that the Constitutional Court declared the unconstitutionality of a political party only in these two cases, only during the 50s. Germany was still not a consolidated democracy. So there was the risk of a return to the previous authoritarian regime, and that's why this is one of the reasons that contributes to explaining why the court decided to dissolve these political parties. There were other cases, even recently, in which there were political parties whose principles, ideas were clearly not in line with the democratic principles, but the court decided not to dissolve these political parties because it said that there was not a concrete danger for Germany to become an authoritarian state, or there was not a concrete danger that this political party could have become so powerful as to put in danger, as to threaten the democratic principles. So the context in this case, in my opinion, made a difference. In the last part of this presentation, I would like to stress a couple of aspects. The first one regards the success of the centralized system of constitutional adjudication. In my opinion, it was really successful. I know some scholars don't agree with me, but this is my point of view, and I will try to explain you why. And then I will also tell you some of the factors that have affected the action of the Constitutional Court. I will talk about three factors, so the procedural gateways to the Constitutional Court, the context, and then the Europe, what I call the Europe factor, which I believe is particularly important. So why was the centralized system so successful? I think that there are certain reasons, and this is clearly shown by the case of Europe, by the transitions that took place in Europe. The first reason has to do with the very role and function played by Constitutional Court. Because unlike ordinary judges, Constitutional Courts have a very, very, very specific task, which is to defend the Constitution, which is to uphold the normative value and the supremacy of the Constitution. This is their main task. Ordinary judges also have other types of functions. The court has mainly this role. And this, I think, also contributed enormously, at least in Europe, to spread, to favor the establishment of a constitutional culture in the country. The adoption of a constitution, guys, is obviously very important to mark a discontinuity between the previous and the new democratic system. But it's also very important that there is a body that proclaims these principles and values. And this is what the Constitutional Court did, especially in the first years of their activity. In Spain and also in Portugal, there are several scholars that have written extensively about this role played by constitutional courts in, favoring and spreading, this idea of constitutional culture. Also sociologists, for example. Then there is a very practical reason, the lack of the purge of the judiciary. When you have an authoritarian regime that lasted for a long period of time, and the old judges are not replaced with the arrival of the democracy, adopting a decentralized system can be risky. You have judges appointed or trained under the previous authoritarian regime that might not be particularly sensitive to the principles and values of the new constitution. Adopting a centralized system, so granting the power to check the constitutionality of laws to an ad hoc body, whose members are selected, is probably contributes, to guarantee the supremacy of the constitution.
Probably the Italian case shows it very well, because we have, as Professor Biaggi said in the previous hour, we had 8 years of judicial review legislation assigned to the Supreme Court, while the Constitutional Court was in the process of being instituted, and in that period the Supreme Court was not really effective in enforcing the Constitution. We had to wait 1956, the first judgment and the following ones, to have the Constitution really operating as a filter against previous legislation.
I will come back, in fact, to the case of Italy to show this in a second. And then there is also a third element that we can consider, the issue of timing. Overall, in my opinion, the Constitutional Court were quite rapid in proclaiming the supremacy, the normative value of the Constitution. Obviously, there were also some exceptions. I told you before that in the field of public order, the Constitutional Court of Italy was probably excessively cautious in certain cases. So it took a lot of years before the legislation in the field of public order was declared unconstitutional. So, as I said, there were also certain negative exceptions, but overall, in my opinion, the Constitutional Court were quite rapid in their action. And strictly related to what I've just said, it is important to consider the factors that have affected the activity of the courts. And this probably will show you even better why the centralized system worked pretty well. Let's consider the first element, the procedural gateways. And here it is important to draw a comparison between Germany, Spain, Portugal, and all the Central and Eastern European countries on the one end, and Italy on the other end. Because in Germany, Spain, Central Eastern Europe, there were a number of procedural gateways to the Constitutional Court. There was a wide access to the Constitutional Court. It was easy for public authorities, for the courts, in some countries also for individual citizens to apply directly to the Constitutional Court. As I said, Verfassung Beschwerde, Recurso de Amparo. In Hungary, there was the Actio Popularis. This wide access, guys, in my opinion, in the context of transition, had certain important advantages in the short term. They increased the chances for the judges to rule on important issues concerning the transition. For example, the protection of fundamental rights. For example, the issues concerning transitional justice. But this wide access, guys, also has certain risks, especially in the medium and in the long term. The case of Spain is evident. The recurso de amparo, the possibility of individuals to directly lodge claims before the Constitutional Court, worked very well in the first 6-7 years of its activity. But then the Constitutional Court started to be overloaded by cases. And this obviously hindered the possibility of the court to carry out its role in an effective and in a timely manner. So when we are in the context of a constituent assembly, if we are, let's imagine that we are constitution makers and we have to decide whether to adopt a wide access to the Constitutional Court or not, these are certain risks that we have to take into consideration. It may be a good decision in the short term, but it also presents certain risks in the long term. This is shown also very well if we make a comparison with the case of Italy. Because in Italy, guys, there was one main procedural gateway to the Constitutional Court, at least until 1970. The incidental method of constitutional review. Probably you are already familiar with it. So when an ordinary judge believes that the law that has to be applied to the concrete case is in contrast with the Constitution, the judge has to suspend the case and refer the so-called question of constitutionality to the Constitutional Court. The court will decide whether the law is in contrast or not with the Constitution. This is the so-called concrete constitutional adjudication. Constitutional questions, exactly. The other procedural gateway, the direct method, so the possibility for the state to impugn regional laws and vice versa, the possibility for the regions to impugn state legislation, was almost non-existent for the first, or was very weak for the first 15 years of its activity, because in Italy the regions were established only in 1970, the ordinary regions. So the success, guys, of the action of the constitutional courts, and this is crucial, depended on the role played by the ordinary courts. And here we have to draw a distinction between the apex courts and the lower courts. The apex courts, the Court of Cassation, the Council of State, were quite reluctant to refer cases to the Constitutional Court, even if there was a clear contrast between the legislation and the Constitution. The judges sitting in the lower courts, on the contrary, were much more sensitive to the principles and values contained in the new Constitution, and in fact they referred cases to the Constitutional Court on a regular basis. And in fact, what we can say is that the ordinary courts, and the lower courts in particular, and the Constitutional Court formed an alliance in order to implement the Constitution. And my question, guys, is the following. Why do you think that lower courts in Italy, in the period that also Professor Dani said, 1948, in the period immediately after what Professor Dani said, so 1956 to the end of the 60s, why do you think that these courts were more sensitive to the principles and values contained in the new Constitution, and why they refer cases on a regular basis to the Constitutional Court, whereas the judges sitting in the apex courts, Court of Cassation, were quite reluctant to do so? Is it a coincidence, or do you think that there is a concrete explanation for this? Excellent. This is one of the explanations for this. Lower court judges were much more sensitive because they had not been trained under the previous fascist regime. Whereas for apex court judges, which were used, to operate under a non-democratic regime, it was much difficult to have this sensibility. So my conclusion is that if lower courts had not been so sensitive to these new principles and values contained in the new Constitution, the fascist legislation, the elimination of the fascist legislation, would have run into even greater difficulties, especially in the light of the fact that, as I said, the recurso in via incidentale, the constitutional question, was basically the only procedural gateway to the Constitutional Court. If the ordinary judges had not referred cases to the Constitutional Court would have not been in the position to declare laws unconstitutional. So luckily, the ordinary judges did so. I will, since we are running out of time, I will only mention very briefly another factor, the Europe factor, which I think can be particularly important and can show the differences between the generations. When I say Europe factor, guys, I'm referring to two things. First, the access of the countries to European supranational organizations, so to the Council of Europe and to the European Union. And I'm also referring to the influence that the European Court of Human Rights, the European Convention of Human Rights, and the European Court of Human Rights, so the Court of Strasbourg, had on these transitional countries. And guys, this Europe factor had a very, very favorable impact, especially for the third generation of constitutional courts, for the post-Soviet constitutional courts, for two main reasons. The first one, the reforms that were required to join these supranational organizations had the effect of speeding up the process of democratization. And this helped indirectly the activity of the courts. In order, guys, to become members of the European Union, you have to meet certain democratic standards. rule of law, protection of fundamental rights, protection of minorities, and so on and so forth. This indirectly helped the action of the Constitutional Court because the court were operating in an environment that was more favorable to democracy. And second, the courts of Central and Eastern Europe, this is probably the most important part, made almost a systematic reference to the jurisprudence of the European Court of Human Rights. This was of the utmost importance because it not only strengthened the judgments of the courts, but it also reinforced their position, their legitimacy, their credibility within their domestic legal systems. These courts of Central and Eastern Europe were very often accused by other institutions. They were, in some cases, for example, Parliament ignored the judgments of these constitutional courts. So relying on the case law of such a prestigious supranational jurisdiction, the European Court of Human Rights, was a way to reinforce their legitimacy also within the domestic legal order. And in fact, if in Italy the best allies of the Constitutional Court, of the Italian Constitutional Court, were the judges, were the domestic judges, the judges of lower courts, as I told you before, in Central and Eastern Europe, third generation, the best ally of the Constitutional Courts was given by the European Court of Human Rights, so a supranational jurisdiction. So my conclusion from this point of view is that the more Europe became a Europe of rights, the more the constitutional courts were able to increase, to strengthen their legitimacy and to strengthen also their action. I will conclude, guys, with this. Overall, my assessment is positive with respect to the role played by constitutional courts in Europe. I think that one of the most important merits that they had, guys, was to contribute to the fact that European countries had not only a constitution, but they also had constitutionalism. And I think that you probably have already discussed about the distinction between constitution and constitutionalism. I'm oversimplifying, but you have a constitutionalism when you have an effective system of protection of fundamental rights, when you have an effective separation of powers. Constitutional courts played a very important role from this point of view. They made sure that what was formally stated in the Constitution, the law in the books, corresponded to, what really happened in practice, to the so-called law in action. Okay? So that's why they contributed to avoid the risk of having a constitution without constitutionalism. I conclude with this. Can we say, on the basis of the European experience, that the existence, the presence of a constitutional court in itself is sufficient to guarantee the success of a democratic transition process? And my answer is no, no, and no. For the following reason. You heard about the so-called Arab Spring, the revolutions that took place in Arab countries. You have to know that a lot of these countries have also experienced certain constitutional transitions. They have, in certain cases, set up a new constitutional court. They have reinforced the prerogatives of the existing constitutional courts. And what is interesting is that in some cases, the challenges that these courts are currently facing are not too different from the challenges that European constitutional courts faced in the last century. But there is a big difference there are many differences, but there is also one important difference between Europe and the Arab world, which is the following. In Europe, guys, when courts were operating, the democratic ideal was particularly strong, was probably the strongest ideology supported by the leading political forces. In the Arab world, guys, this is not the case. It is true that the democratic ideal is consolidating more and more among the population, but there are still a lot of non-democratic ideologies. Authoritarian presidentialism, authoritarian monarchy, Islamist fundamentalism, and so on and so forth. So the zeitgeist, the spirit of the times, is certainly not entirely favorable to democracy. And obviously, guys, this affected enormously, is affected and is still affecting enormously the role played by constitutional courts. If in Europe they were so successful, it is also because of the environment, of the ideology in which they were operating that, as I said, was favorable to a democratic culture. In the Arab world, one of the reasons that explains why constitutional courts are facing so many difficulties is given by the fact that, as I said, the zeitgeist of the region is certainly not particularly favorable to the democratic ideal. And with this, I will conclude my presentation. Thank you, guys.
I think we are very grateful to Professor Francesco Biagi for his presentation and for the number of inputs he has given us with this comparative survey on the operation of these three constitutional courts contributing to the establishment of constitutional democracy. He has also showed us, in particular in the last part, the limits to the potential contribution of constitutional courts. Constitutional courts are part of a broader picture. They can't be expected to do all the work. The work of establishing a successful constitutional democracy is, I would say, mainly political, and constitutional courts within a functioning legal and political order can offer the possibility. But we can't expect a constitutional court to promote constitutional democracy in a context which is inimical or dubious vis-à-vis the idea of constitutional democracy. Having said this, we have still some minutes for questions and answers, for if there is a need of clarification, if you have curiosities, if you have comments. So, please.
Yes,
Julia,
please.
Can I use? Because we are recorded.
So do you think that Arabic countries will be a sort of fourth generation of constitutional courts?
What we can notice is that constitutional adjudication in the Arab world has become particularly important following the Arab Spring. As I said, two countries, Jordan and Palestine, have decided to establish a constitutional court. Many other countries have significantly reinforced their powers and their prerogatives. So, from a formal standpoint, constitutional adjudication is on paper, so on the basis of what we see in the Constitution, has certainly become one of the most important features of Arab constitutionalism. This is for sure. On the other hand, however, I've also tried to identify some of the limits that these constitutional courts may have, because they are operating in quite an unfavorable environment, as Professor Dani has said. So what I would say is that they have maybe in the future the potential to become important actors in these processes, but if the political context will change. And from this point of view, I can give you maybe quite an interesting example. Among the Arab countries, one which is certainly quite advanced in the process of democratization is Tunisia. Unfortunately, the Constitutional Court of Tunisia has not yet been established, but in my opinion, when this court will be established, it will be able to operate in an environment which is probably more favorable to the democratic ideal compared to what happens in the vast majority of all the other Arab countries, which are still either non-democratic or, in the best case scenario, hybrid regimes. So, with respect to the case of Tunisia, I'm quite optimistic. With respect to all the other Arab countries, on the contrary, I'm quite skeptical about the role that this course will be able to play in the short term. Maybe in the medium and in the long term, things will change if, as I said, the political environment will change. I don't know whether I managed to respond to your question.
I had a question in regards to the third generation that was mentioned, and I was thinking, could we consider the, let's say, the environment as favorable for this success of this particular tradition in regards to the tendency to involve the experts of, for instance, civil law, legal family, in the drafting of the new civil codes that are operating and that still give the reason to call the post-communist countries countries in transition. So could we consider that the environment is favorable for the establishing and the sufficient operation of the constitutional courts because of the involvement of the civil law legal family in the drafting of the current civil codes?
Well, I mean, this could have had potentially a positive impact. I'll say, I don't know whether you are referring to something in particular, but my general impression is yes. I mean, if your question is yes, your question was yes or no, yes. I would be in general I agree with you, and I would say that this was favorable, conducive to the establishment of a democratic system from this point of view. If I correctly understood your question. I mean, the existence of a civil law tradition you're referring to, right?
Yes, so basically what I'm talking about is actually the influence on the post-communist countries in terms of shifting to different legal traditions in regards to establishing the constitutional courts. That's what I was thinking about, whether it is a favorable environment or sufficiently operating.
In my opinion, it was, in the sense that there were still obviously influences of the previous non-democratic regime, and as I said, there were people who were still interested in a return to the previous authoritarian regime, and that's why, for example, the lustration laws have been adopted. But overall, I'd say that with the fall of the Berlin Wall, with the collapse of the Soviet Union, the democratic ideal was certainly prevailing. There are two very important political scientists, Linth and Stepan, who made a comparison between Europe between the two world wars and Europe at the end of the 80s. They said that between the two world wars, the zeitgeist, the spirit of the times in Europe was certainly not particularly favorable to democracy. So democracy was only one of the different contested ideologies, together with fascism, Nazism, and many others. At the end of the 80s, on the contrary, the democratic ideal was probably the only real, strong, and powerful ideology that existed at the time. Communism was about to collapse, fascism had been defeated, Nazism had been defeated, and so on and so forth. So from this point of view, I would say I agree with Stepan and Linth, so that the zeitgeist, as I said, also in this period of time was certainly particularly favorable to the democratic ideal, and therefore this contributed also to the role and the action played by constitutional courts.
We may perhaps add to this answer that problems have arisen later in time. After the first embrace of constitutional democracy in Central Eastern Europe, more recently we have witnessed disenchantment and perhaps an opposition to the very idea of a constitutional democracy, of a constrained democracy. What you keep on hearing often and often in the Visegrad area is the idea of an illiberal democracy, which is even openly advocated by the like of Orban or the Kaczynski, by Kaczynski, the head of the Law and Justice Party in Poland. And this is emerging as a problem precisely because it is challenging the very idea of constitutional democracy that is still predominant and hegemonic. And the challenge is quite successful in that it doesn't seem that in those countries there are valuable restraints towards this. And when I say restraints, I'm referring essentially to political restraints. So you haven't seen a strong opposition against that. Perhaps the case of Poland could end up being a case in which we will see some opposition emerging. But for instance, in Hungary, political opposition against a liberal democracy has been extremely weak. Also because, and this is the other element we should take into consideration, constitutional democracy is challenged and questioned also in what used to be Western Europe. The commitment towards constitutional democracy is wavering also in countries like Italy, in countries like France to some extent.
And if I may add one very short point about that, it's not a coincidence that when the new constitution of Hungary was adopted, the powers and the prerogatives of the Hungarian constitutional courts were severely restricted. And guys, the Hungarian constitutional court was considered, with reason, one of the most powerful and activist constitutional courts in the world. So one of the first things that Orban decided to do was to constrain, to limit the powers of this constitutional court, because it was seen, it was considered, potentially, challenging, his government. So constitutional courts are, in certain ways, in certain countries, certainly, also threatened with respect to their action and role.
Any other questions?
Yes, please.
So you talked about the reasons that led to the success of the centralized system of constitutional review in Europe. But what do you think is the position of this system right now? Can it be threatened by some factors such as EU law and the fact that also ordinary courts have to apply it, and also reasons such as the fact that now authoritarian regimes are very old, like in history, and so it cannot be a reason anymore? And would it be better to have a decentralized system in Europe, or
Thank you very much. This is a very difficult question, but very important. What we can notice, guys, is that even countries that have adopted a centralized system of constitutional adjudication, in actual fact, it is more and more evident, it is possible to see more and more evidently the elements of a decentralized system. The fact that ordinary judges are more and more involved in constitutional adjudication. So we are still dealing, at least from a formal point of view, with a centralized system, but as I said, the involvement of ordinary judges is more and more evident. So there are elements of decentralization also, for example, in Europe, and these are more and more evident. The second issue that we have to consider is the European supranational dimension. No, we are dealing in a context of multi-level protection of fundamental rights. So rights are protected at the domestic level by courts, by constitutional courts, but they are also protected at the supranational level by the European Court of Human Rights and also by the Court of Justice of the European Union. So what has happened in the past few years more and more is a sort of dialogue also between national courts, domestic constitutional courts, and European supranational organizations and courts, and in particular the European Court of Human Rights and the Court of Justice of the European Union. So now the challenge is that domestic courts, and this is one of the fields where Professor Dan is an expert, but I don't know whether you agree with me, but one of the challenges that now more and more constitutional courts, domestic constitutional courts, have to face is precisely this relationship with supranational jurisdictional courts, including European Court of Human Rights and the Court of Justice of the European Union. Obviously, they also have to face certain challenges with respect to certain illiberal tendencies. It's not a coincidence that in Hungary, where there is an ongoing illiberal tendency, as I said, one of the first things that Orban did was to restrict the power prerogatives of the Constitutional Court, but also Poland. I think it's another example. In Poland, the powers, the independence also of the judiciary is more and more threatened by the action taken by the government. So there are different types of challenges. There is a decentralization. There are the challenges regarding the relationship with European bodies, jurisdictional bodies in particular, and then there is also potential dangers, because of these illiberal tendencies.
Any other comments? Okay, I think we can stop here. Thank you again.
Thank you very much, guys. And thanks also for your questions and comments.
And we have the last class next week on Monday. So see you next Monday for the end of the course, basically.